All right. Good evening, folks. Welcome to Monday Night Law here, Kirk's Law Corner. I don't know if this is working out on X, formerly known as Twitter. My software app here said that I can broadcast on X, so I don't know if this will be a new edition. I don't see anything yet over here, but it may or may not be live. Oh, it is. It is live on X. Woohoo! All right. One more social media to broadcast to. All right. All right. Thank you, Alaska Tiger. Or Tigger, whichever way you pronounce that. And Corruption Detector, good to see you, brother. Missed you for Wednesday night workshop. All right. Well, this is quite awesome. Got that all set up just in time to make this all happen on Twitter or X now. Okay. Pause that. So there's a couple things going on. I guess there's a deal out there. Can't remember what his name is off the top of my head. I know I've got it here somewhere if I'm going to scroll down and look. Of course, that's on my own. But he's doing a thing for the military to hold them accountable, should be responsible for the mandates, supposedly. And like I've explained before, mandate is comes from a writ of mandamus from the judicial branch to a lower court or to a public servant to discharge the duties of their office. Otherwise, a mandate is like two men going fishing or the Obamas going to see a movie. That's a mandate. Other than that, no. Comes from the writ of mandamus, and that is from the judicial branch. And again, it's to public servants. It can never be to the people. It's not how writ of mandamus works. So hopefully I can get in contact with these people. I was on part of their call just a few days ago on Twitter, on X. And actually Matt Gaetz was on there. Marjorie Taylor Greene was on there. There's some other people on there. So Thomas Klein, good to see you, brother. Jax, James, Ernie Yordi, this all over on YouTube. I don't see anybody on Facebook commenting yet. Big Mike took a hike. Oh, you guys kill me sometimes. So, little update on the office. Most everybody on Telegram has basically gotten the update. Again, there's brother Rob. How you doing, Rob? Over on Facebook. Just wanted to let people know that I've moved offices directly upstairs. And not with God, but I mean, I am with God, so. But in the same office building, I now have a classroom set up. So I'll be hosting some private classes and stuff through here, locally. Most of it's going to be, well, I wouldn't say most of it, but in part, obviously, private law classes. But the main thing is doing the Idaho assembly stuff and hosting private classes there for the local people from Idaho to come together, which I actually did a live law seminar, Saturday at a Caldwell Christian Church, but it decided to start to snow about 2 hours prior to, and boy did it just dump. So I think that prohibited a lot of people from even coming. So the turnout was not very big, but definitely got a few people interested in joining the General Assembly for Idaho. So our numbers are starting to pick up, and want to do kind of a quick shout out to Dawson. He's a little go-getter out there. He's trying to bring people together within this group out there called Freedom Group. So saying hi to you folks out there, if you're watching either live right now or watching this later. I'm hoping to get the minimum 35 together here shortly, so we can do the proper paperwork and get this done and go into interim and start working on assembling the counties. But we have to do the state level stuff first. Many people don't grasp the concept of you can't have a county without a state. You got to have the state assembled first, and then you can do the counties. And there is proper paperwork that has to be done. And these guys at national-assembly.net are the ones that have been doing this since 2011, 2012 with Michigan, start of Michigan, which Carl Miller was part of that. And this is what I've been looking for. Diesel D's, how you doing, brother? Looking for that since I found Carl Miller back in 2014. And there's the usual people out there. And I found several different ones out there trying to do this, but none of them seem to be doing it right. And I just had a bad feeling about one in particular. And I'm not going to name names or anything, but because I know some people get triggered on this, especially when it comes to the word national as a noun. So many people, oh, I'm an American state national, blah, 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 blah. Really? Can you cite the law that comes from? The only real place to find it's in the United States Code, which is under the United States Inc. These are the corporate bylaws of the United States Inc. And it was created by the United States Inc., which was created in 1871. The word national as a noun did not come into being as a status, supposedly, until 1878, under the corporation. So I don't get why these people don't get it, that when you say you're national and you've corrected your status, supposedly, and the whole idea and concept behind it is to pull yourself out of the corporation, but yet you're using a term from the corporation. You're actually putting yourself back in under the corporation. The correct status is here in America is citizen, people, and inhabitants. Notice you didn't hear the word national in there. Yeah, those terms come from the Law of Nations, a body of law known as the International Law of Nations. So, those of you out there that have supposedly corrected your status to a state national, you just put yourself back under that corporation, which, by the way, is bankrupted. I don't understand how that could even work. But it just removed you from the ability to become under the true stuff, the real stuff, government de jure, the lawful stuff. So, Hello, Scott, over here on Telegram. So just to kind of educate the people on the truth there of what a national is and where it came from and where it comes from. You're not gonna find it in the Law of Nations, because the Law of Nations was written prior to 1776, definitely prior to 1787, or pardon me, 1878, when the word national was created as a noun, as a status. So please stop with the national stuff. We're supposed to be an American. Supposed to be one of the people. And here's one of the biggest clues. All political power is inherent in the people. If our founders meant that nationals was to be a status here in America, they would have said all political power is inherent in the nationals. But they didn't, because national didn't exist. And feel free to go look it up in etymology, and you'll find the origin of the word national as a noun didn't come into being until 1878, or pardon me, 1887. 1887 or 1878? 1878. You get that confused. 1878. 7 years after the Reconstruction Acts of 1871. There's your clue right there. And then the only place you can find it from so-called law is in the United States Code. You don't find it in the Law of Nations. Again, didn't exist. So, right, there's one out there right now. Said almost started the state national stuff, and thankful that they found me. Okay. There, Yeah, well, these people are going to have a hard lesson, unfortunately. I feel bad for some of these people that they were duped, they were lied to. And that just goes to show how dumbed down we are as a society. That we don't question this stuff, that we don't ask the basic question, well, can you show me the law behind this? I mean, just the fundamental principle of in every single state Declaration of Rights, you will find the phrase in there about the all political powers inherent in the people. It's in the Law of Nations that the people is the sovereign body politic. Political powers inherent in the people. Right there. Right from the Law of Nations. Now then, when you get into the definition of a citizen, that comes from Law of Nations, Book 1, Chapter 19, subsection 212, which a citizen is actually the public servants, the members of a civil society who are bound to perform certain duties and is subject to its authority. That's the key. Article 6, Clause 3 says all the aforementioned senators and representatives and all the members of the legislative, executive, and judicial, both state and federal, shall be bound by oath or affirmation to support this Constitution. The public servants are the citizens, not the people. The people are in the private, not the public. And then the other one is inhabitants. That's section 213 of the same Law of Nations, Book 1, Chapter 19, subsection 213. Okay? So, there's the facts of law. I just cited law. Now, I'll ask anyone out there who claims they've changed their status to an American state national to cite the law where national comes from. But I've had run-ins with some of these people, even here locally. And they can't cite any law. The most recent one here was Christmas time, and it was, Oh, well, Black's Law Dictionary. It's a dictionary. We're looking for a source of law. Doesn't exist. Okay? Right? There's another one. Brother Art out here on YouTube that deprogrammed Art's buddy Mike, who's a retired highway patrolman. He was going to do that. And I laid this stuff out to him. No, I mean, it's completely illogical once you learn the truth. The status you really want here in America, if you want to be involved in so-called politics, having political rights, you have to change your status to one of the people. Otherwise, just be an inhabitant is okay. There's nothing wrong with being an inhabitant. It's right in the Articles of Confederation. The free inhabitants, the free citizens, the people. Okay. There, see, I just cited another piece of law that lays out those statuses. Okay? And when they said free citizen back in the Articles of Confederation, they meant the people. Because if you look at Section 213 under the inhabitant, it says there's also a different kind of citizen. Well, that would be the people. See, our founders created a one-of-a-kind form of government. So you really have to be very careful of your sources of law when it comes to America. Okay? That's the biggest hurdle we have, all of us have, is finding the correct law to read and study from. And Fix It Fast out here, he's running around dumping all this stuff out there, so thank you, brother. But my website, kirkslawcorner.com, okay? Go to the library tab and download Law of Nations and verify exactly what I just cited. Book 1, Chapter 19, subsection 212 and 213. There's your definitions of citizen and inhabitants. Okay? And then go look at and read Article 6, Clause 3 of the Constitution for the United States of America. And you'll find the words member and bound. That makes them the citizens. So this totally debunks sovereign citizen, because the people are the sovereign, having the power to create government. That's the whole key to all of this stuff about the assembly stuff. Is bringing the people together, uniting, assembling. Okay? And once you have the people together and you do the paperwork and you declare it and all that good stuff and publish everything that needs to happen there, people don't realize the people have the power to create the instrument of government, the Constitution, conscience, and control the minds of that which they create, which makes the people the sovereign. Now, the public servants are vested with sovereignty, but the people remain the sovereign. That fundamental principle that all political power is inherent in the people. The people have the right to alter, reform, or abolish anything at any time they deem it necessary. That is such a powerful principle of law of our republic. We must come together, unite as one sovereign body politic, and alter, reform, or abolish all of it, any of it, at any time we deem it necessary. And that's even in the Declaration of Independence. That's, even our founders said that in there. And I'm going to pull that up just to kind of point it out, because this is where we've been at for a while. And I comprehend, and then understand that there are a lot of people waking up. Okay? to the corruption. And it's becoming more and more exponential. I'm seeing more and more new people on my social medias. Okay? And some of them are flat out saying, hey, new to your thing, okay? That's because you're out there, you're looking for people that, like myself, that are trying to teach and educate people, that are trying to do the real thing. Oh, we got one of them trolls out here on YouTube. Tell us about your recent conviction. Somebody who hasn't been following it for very long. And tell us if you've ever won a case. Well, of course I've won cases. Technically speaking, prior to this one, which was a second trial, all 4 of those cases were dismissed. So yes, I've won cases. I've won a case clear back in frickin' 1991, 92. That's how long I've been in this game. But these trolls out here want to come in here and talk like I've never won anything or da-da-da-da-da. Whatever, dude. Why don't you go look it up? Trolls. But see, what I'm working on in this particular case is itemizing all the unlawfulness of it. And then I'm going to go tell on them. You know, constitutionality challenges and all that good stuff that most people don't have any clue about how to do that. Playing what I call the long game. Okay? Due process of law doesn't stop at the end of the trial. You have the right to appeal. We have the right to petition Congress pursuant to Article 4, Section 4, to guarantee a Republican form of government. But I'm willing to bet the troll that's over here right now on YouTube has no clue what I just said. Because they don't know jack about the law. They don't know anything about their rights. Oh, one of those guys. Want to bring up former student, right? Because, see, I provide education about this Casey. Yeah, thank you, Diesel D's. There's somebody who's won a case by learning from me. There's a couple of other people that in my private classes where I'm doing education who have won their cases. You see, you don't pay attention. You're not one of them. Maybe you're just jealous. But, yeah. And I don't care if you believe me or not. You're on here as a troll to begin with. And Casey wasn't my client. The thing was, and no, he wasn't convicted thanks to me. This is where you're thinking errors, dude. They quit coming to me. And they decided to get help from somebody else. And the problem is, and Tony Pellegrino and myself have had this same problem. We help people do their paperwork and try to educate them. But when it comes time to go to court, they don't know the law. They don't know enough to effectively defend themselves. And that's the problem. Knowledge. There's a lack of knowledge there. How is it that I can do it for myself and win and get my cases dismissed, but not somebody else doing basically the same exact thing? What's the difference? The difference is, as I have the knowledge, I can articulate it. That's the difference. Proof's in the pudding. The difference between me and somebody else trying to do what I do. Without the knowledge, that's what happens. You get screwed over. You get railroaded. And I'll be the first to admit, they're corrupt. Or did we all forget that? Did we forget that that's what we're at war about right now? Those involved in serious human rights abuse and corruption. Executive Order 13818. Worldwide Executive Order. Wonder if you knew about that one. That's from December 20th, 2017. Worldwide cleanup coming. But it would behoove the people to learn how to tell on these people, how to do the proper paperwork and effectively defend themselves. At the bare minimum, create the record, afford them the opportunity to do the right thing, and when they don't, learn how to tell on them. Because the maxim of law, fundamental principle of law, is the defendant, by pleading or exception, becomes the plaintiff. And like Tony Pellegrino and I have said for years, we want to teach people how to become the plaintiff. But you got to learn. You got to gain the knowledge. So don't try to blame me for what happened to Casey or anybody else out there. I'm not responsible for them. I'm responsible for myself. Everybody else is responsible for their own education. Right? That's a fact. That's the truth. The whole truth and nothing but the truth. So help me God. I am not responsible for your education or any other man's education. And until you can admit that truth, there's no sense in even having a conversation with you. But let's look at the Declaration of Independence, because this goes right along with what I'm just saying right now. Let me get that properly shared here so everybody can see it. Right here, we're talking about prudence indeed will dictate the government's long established should not be changed for light and transient causes. Oh, let us back up. Let's just start right here. We hold these truths to be self, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So you might want to learn about those three fundamental principles of law, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That's a key word, consent. And that whenever any form of government becomes destructive of these ends, it is the right of the people, not nationals, the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles, and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. What was the intent of creating government again for, folks? To secure those rights. That means those rights pre-existed creating government. Just like Hale versus Hinkle reiterates that our rights are long antecedent to the formation of the state. Imagine that. Prudence indeed will dictate the government's long established should not be changed for light and transient causes. So we're not talking about just totally one little tiny little thing and we should just throw it all out the window. No, that's why we have the ability to make amendments. And accordingly, all experience has shown, this is what I'm referring to right here, that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. This is it right here. A lot of people out there bitching and complaining about how they're violating my rights, but will not learn how to effectively defend themselves. Let alone what really needs to be done is the people need to come together and we need to reestablish government de jure. Remember, our government was hijacked in 1861. Okay? Very, very good statement. My sister Jamie Grubbs out here. There is a difference between learning what to think and how to think. Knowledge is key. Absolutely. That is beautiful. And there is a very clear distinction between learning what to think, because then somebody's telling you what to think, versus learning how to think for yourself. And knowledge is power. It will literally empower us. I speak from experience. I've stood toe to toe with Idaho State Police, city police, sheriffs, sheriff deputies, the sheriff's office. Okay? And they've backed down to a certain degree on certain ones, certain happenings or certain events. Okay? So there's a lot more things that I've done in my life within the last few years even, that like certain cases didn't even get created. So how would I show that I won that case when there wasn't a case? Before there was a case, I shut them down. So what about those? Because I can definitely pull up my record and show you the ones that I've won, which I've already put that out there many times. Right here on the show. I've showed them. I've talked about them. When it happened. But again, I'm here of my own free will trying to educate the people. For free. Got anybody else out there doing this? That has the passion to educate his fellow man on what the law really is, knowing that we've all been dumbed down and lied to. What I'm really trying to do is give everybody a shortcut so that you don't have to go through everything that I've gone through to find these golden nuggets and put this 10,000 piece puzzle together all by yourself. I can literally hand you the pieces and help you put it together. And we work together on this. So, but this is where we're at, folks. And this is our founders saying this in 1776. In their experience, that mankind are more disposed to suffer, while evils are sufferable than to right themselves. Meaning, do something about it. But you can't do something about it if you don't know, you don't have the knowledge. Knowledge is key, folks. Without the knowledge, we have nothing. You know, and here's the next part. When a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. So it's not just a right, folks. It's a duty. But how are we going to perform those duties if we don't have the knowledge? It's literally impossible to bring this into fruition if we don't have the knowledge. Now, I want to thank those over there at national-assembly.net, which is another educational program, just like mine, providing education, trying to educate the people how to do this, to do it lawfully, do it the correct way, the lawful way. Because make no mistake, this has to be done the correct way, the lawful way. And while some people out there claim they know, they don't have it, they're not doing it the lawful way. And I'm so happy that I finally found them. The truth. The ones that have actually done it and have the support of the military. That's the key, folks. Having the support and backing of the military. So, again, thank you, brothers and sisters over there at the national-assembly.net and the folks out of Michigan who originally started this stuff with Carl Miller way back in the day. Okay? Oh, Brother Mark, good to see you on here. Yeah, I haven't seen you for a while. Hope everything's going okay for you. I see you've been working on your mom's estate stuff. Maybe that's what's been keeping you away a little bit. But this right here, and I want to talk about this absolute despotism because there's a key to this. Right here. No, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions only have been answered, I don't know what that, have been answered only by repeated injury. Okay, here's the thing, here's the key. What's the difference between absolute despotism and despotism? The key difference is petitions. Petitions are political lawsuits, like Article 4, Section 4 talks about in Luther versus Borden. Under Article 4, Section 4, it is a political argument, not a judicial one. It is up to Congress to determine what the Republican form of government is in a state. Oh, would that be part of our Republican form of government and one of the duties and powers delegated to Congress pursuant to Article 4, Section 4, where it says on application of the legislature or the executive, the legislature can be convened for domestic violence. Luther versus Borden lays it out that domestic violence is internal insurrection. Oh, that means to overthrow the Constitution, which is the laws of creation, and war against the people. That's what that despotism is. Gee, I don't know. What's that right here? He has excited domestic insurrection among us and has endeavored to bring the inhabitants, oh, there's that word, inhabitant, of our frontiers, the merciless Indian savages' own rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. How dare we talk about the Indian savages that were murdering themselves before we even got here? But I always like to remind people there were at least 3 different types of people that came over here to begin with. The red coats, the blue coats, and the no coats, which were the good Christian Protestants trying to flee from England from the Roman Catholic Church, Catholicism. That's the truth. Whether you like that truth or not is irrelevant. It's a fact of law. But again, back to the petitioning part, that's, one of the powers of Congress to make sure that we're not turning not even just one state back into a monarchy. That's it. Happy New Year to you, Brother Mark. And just an FYI out there, Danny Mayer Jr., the United States Inc. Corporation was involuntary bankrupted in June of 2020. We're done. I've actually got the documents on it now to prove it. Fact. Done by Trump. It's over. Well, yeah, I get that, Danny, that we've been overrun. But I tell you right now, we the people outnumber them. I can't even begin at 100 to 1 easily. We're up to what, like 350 million people in America? And we're talking about maybe less than 1,000 people? Really? But the key is all political power is inherent in the people. The people have to come together, folks. That's the ultimate goal here. The resolution or the relief, remedy and relief that we seek. The remedy is due process of law. To get the relief that we seek, to get rid of the corruption, following due process of law, we need to reassemble the people. There is no other way around this. There is no other way to do it. Some people will say, oh, there's more than one way to skin a cat or whatever. Not in this instance, there isn't. Due process of law dictates the process, and the law dictates the paperwork that has to be done. Now, the folks over there at national-assembly.net have figured that out long time ago. Gee, it came from the military. Imagine that. Okay? Right? No, that's the thing, folks, is this is the fix. And what is it? What are we talking about here? We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. Oh, what was that? We have reminded them of the circumstances of our immigration and settlement here. Would that be because they're trying to separate from the Roman Catholic Church, Catholicism, as an ideology? And the Christian Protestants wanted Christianity as an ideology where man is created by man. Man is a creation of God and we're endowed by our Creator with certain unalienable rights. That's what they're talking about. That's exactly what I was talking about. The reason why we came over here. They were reminding them of the circumstances of their immigration and settlement here. Was to get away from the Roman Catholic Church. And that form of government. Which our form of government started to be created with the first ordinance of Virginia of 1621. But when they first come over here was 1606. Jamestown, Virginia. the first charter of Virginia, 1606, folks. A lot of people are been taught, oh, it was the Plymouth, or the Mayflower comic, New Plymouth. No. We already had 14 years of law prior to the Mayflower. And then if you read the Mayflower Compact, it says, oh, we're settling in the northern parts of Virginia. Well, wait. Wouldn't Virginia have to exist in order for those folks that came over on the Mayflower to settle in the northern parts of Virginia? It would, wouldn't it? Yep. That's why reading means reading. The troll wants me to talk about Ammon Bundy's legal trouble. Yeah, there's perfect example. Somebody who didn't want to listen. In the rules of procedure, you're supposed to, after you've been properly served with a summons and a complaint, you're supposed to answer. And you do counterclaims. I mean, here, let me put it on the screen. It's called Rules of Procedure. Rule 12, defenses and objections. When and how presented. Motion for judgment on pleadings. Time to serve a responsive pleading. By the way, I posted this on the website. In general, less another time is specified by the rule statute. The time for serving a responsive pleading is as followed. A defendant must serve an answer within 21 days after being served with the summons and complaint. It's almost like I know what I'm talking about. Because I've read this before, I've been through this before, I've already done this. A party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim and cross-claim. A party must serve a reply to an answer 21 days after being served with an order to reply, unless the court specifies a different time. This is how it's done. And the fact is that he didn't do that. And see, this is the key. Could have taken down CPS. We could have taken down St. Luke's. Because, see, counterclaims is where you counter their claim, and then you turn around and you make your claims. It's called a cross claim. So you counter their claims, and it goes something like this. Oh, so-and-so says this, and that's not true. In fact, the truth is, so that's a counter claim, right? Because these are presumptions in the record. And then the cross claim is where you make your claims, like, oh, this woman over here at St. Luke's made a false report to CPS for medical neglect. That doesn't meet the governmental compelling interest, the strict scrutiny standard test. Because our health as a whole is none of government's business. And not only that, the whole supposed medical industry, they don't do medicine, they do pharmaceutical drugs, which are all synthetic, filled with poison. None of it is designed to cure anything. Prove me wrong. So the next part is we could have taken down CPS because CPS should have said, well, there's no governmental compelling interest here. Just because the mother and father decided not to take their child in for the doctor visit does not constitute any kind of neglect, willful, which is mens rea, criminal in nature. See, it has to be criminal in nature. There's no such thing as civil in nature when it comes to neglect. Okay, and this comes from the common law. right out of, I actually found this in Bouvet's Law Dictionary, 1856, is neglect of food and clothing. So if there's a willful, with malice, criminal in nature, mens rea, willfully depriving the child, neglecting the child of food and clothing, there's a governmental compelling interest. The other ones is physical abuse or sexual abuse. That's it. So, if you would have done his counterclaims and then done his cross claims and claimed that the woman from St. Luke's made a fraudulent phone call, fraudulent claims, then CPS conspired with that woman who made the fraudulent claims. Then Meridian Police conspired. Then the court conspired. Oh. And then, I don't know, a petition to the legislature, pursuant to Article 1, Section 2 of Idaho's Declaration of Rights, to revoke St. Luke's business license. Because, see, there's one of those rights that dictate the process. I wonder if the troll out there thinks maybe they should have listened to me. Maybe the troll out there might have a little bit of an understanding that I actually know what I'm talking about. That I actually know this stuff because I've done it. Let's see if the troll can correct themselves and acknowledge truth. But most trolls don't. They're just here as negative Nancy. And they don't care about the truth and being properly educated and understanding why what happened to Ammon Bundy is his own damn fault. And there's plenty of other deals that could have been done. No, I would say, let me rephrase that. There's plenty of other parts of due process of law that could have been carried out, even if he got railroaded in this particular case. Could have been an appeal. Could have been, a petition to the legislature or Congress. But what does this say here? See, this is a going joke that I've had for many years. But it's not really a joke, it's the truth. Why is it when we go to sue them, the first thing that they file is a Rule 12b-6 motion to dismiss? Gee, what's Rule 12b-6? 6 is failure to state a claim upon which relief can be granted. It is their number one go-to thing as soon as they're served with a summons and a complaint. So my question is why aren't we doing the same thing? Every time, the very first thing that should be done. Should be challenging jurisdiction. Right here. 2, 4, and 5. This is an automatic dismissal. And in fact, any one of these grounds for dismissal is an automatic dismissal if it can't be proved. But you have to do the paperwork. What does it say? Every defense, in law or fact, to a claim for relief in any pleading, whether a claim, counterclaim, cross-claim, or third-party claim, must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. Okay. But that's the key. You have to have this knowledge. A little tiny bit of reading and basic comprehension and understanding, you can do this. And you know what? This is in my educational series. Yep, sure is. That's out there on YouTube for free. It's also on my Facebook page for free. People I know that there's certain people that have watched them and have learned from them. No, Ammon Bundy did not do any paperwork. He did no paperwork. He did not do an answer. He did not do a motion to dismiss. He did nothing. In fact, the first thing he really should have done was called a notice of special appearance. That's Rule 4.1. Right here. Rule 4.1, general or special appearance, the voluntary appearance of a party or service of any pleading by the party, except as provided in subsection B of this rule, constitutes voluntary submission to the personal jurisdiction of the court. Imagine that. What's the exception to the rule? Rule B. The following do not constitute a voluntary appearance by a party under this rule. A motion under Rule 12B, 2, 4, and 5, whether raised before or after judgment. Uh-oh. He could still do it. But the main one right here, even after you do your notice of special appearance and you do your motion to dismiss, and even if it's denied, does not constitute jurisdiction. It is not a voluntary submission to the personal jurisdiction of the court. Even if you, after you do this, and what does it say? It tells you flat out what to file. Filing a document entitled, quote, special appearance, end quote, which does not seek relief but merely provides notice that the parties enter in a special appearance to contest personal jurisdiction if a motion under Rule 12B, 2, 4, and 5 is filed within 14 days after filing the special appearance or within such later time as the court permits. Well, right here in the rule, it permits at any time, whether it's raised before or after judgment, so long as you do the notice. Because that's the first fundamental principle of due process of law. Notice an opportunity to respond. You have to give notice. Otherwise, by default, it enters in a voluntary admission or submission to the personal jurisdiction of the court. That'd be episode 2 in my educational series from well over 4 years ago. But hey, I don't know what I'm talking about. I haven't won any of my own cases or none of that crap. False. All right, folks. Enough of that. Let's get into learning some real law. Let's pick up where we left off last week on absolute rights, because, like people's rights. Don't you think you should learn your rights? So we left off here a little bit further down, but I marked it at, section 131. So, from last week was part 2, and the one from before was part 1. So this is part 3. What you got there? Thank you, Jimmy, for sharing the documents over here on Telegram of the bankruptcy. All right, the constraint a man is under in these circumstances is called in-law duress. Okay, this is where we're talking about, maybe we should back up to get the full context here. Both the life and limbs of a man are of such high value in the estimation of the law of England that it pardons even homicide if committed sed defendendo, self-defense, or in order to preserve them. For whatever is done by a man to save either life or member is looked upon as done upon the highest necessity and compulsion. The maxim of law is what a man does in his defense is to be considered legal. Should be lawful, but. Therefore, if a man through fear of death or mayhem is prevailed upon to execute a deed or do any other legal act, these, though accompanied with all other the requisite solemnities, may be afterwards avoided if forced upon him by a well-grounded apprehension of losing his life or even his limbs in case of his non-compliance. Now, this is from Blackstone's Commentaries on the Law of England. And here in America, we made it even further, defending our property. That's right. We have the right to use arms up into, including killing a man. Here in America, we have that right. It comes from the laws of nature. We have the right to defend our life, our liberty, our property. And that John Bad Elk versus United States, somebody found that and shared that. So, again, thank you for whoever found that and shared it. That's it, John Bad Elk versus United States. I highly recommend people read that sucker. You'll get a full comprehension of what it means to effectively defend yourself, up into including killing two police officers or sheriff deputies who didn't have a warrant when they came to John Bad Elk's house trying to put their hands on him. That's right. The laws of nature. Oh, there's a whole other body of law to learn. The laws of nature dictate which the right of self-defense, which actually New York State Rifle Pistol Association versus Bruin out of New York went all the way to the Supreme Court of the United States, and that's what they ruled. They cited Blackstone's Commentaries on the Law of England. The laws of nature and the right of self-defense is at the root of the right to keep and bear arms that the Second Amendment was intended to protect. Uh-oh. There's a change coming here in America, folks. I'm telling you that right now. It's already happening. Most people are just not aware of it. All right. So, and the same is also sufficient excuse for the commission of many misdemeanors, as will appear in the fourth book. The constraint a man is under in these circumstances is called in law duress, from the Latin durities, of which there are two sorts: duress of imprisonment, where a man actually loses his liberty. Now, in the Treatise on Arrest and False Imprisonment, it's called false imprisonment. That's right. The second the man tries to dictate to you whatever uniform he's wearing, that disguise he's wearing, and I use the word disguise because that's what 18 U.S.C. 241 talks about, was out on the streets and highways in disguise. Because, see, we're all created free and equal. It doesn't matter what he's clothed with authority. He loses. He can't. Because we have to understand the fundamental law, the laws of nature, God's law, at the root of it. That can't be changed. And every man is duty bound to know this, because rights impose that duty. You can't claim ignorance of that body of law. That's supposed to be self-evident. But duress is fraud, where a man actually loses his liberty. So when you're being deprived of your personal liberty, which is the right to the power of locomotion, sometimes referred to as the right to travel, but the real right is the right of personal liberty, of which we shall presently speak, and duress per manus, Latin again, where the hardship is only threatened and impending, which is that we are now discoursing of. Duress per minus is either for fear of loss of life, or else for fear of mayhem or loss of limb. And this fear must be upon sufficient reason. Non, as Bracton expresses it, suspicious, blah, 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 blah. Whew. Way too much Latin there. I'd have to look that one. A fear of battery or being beaten, though never so well grounded, is no duress. Neither is the fear of having one's house burned or one's goods taken away and destroyed, because in these cases, should the threat be performed, a man may have satisfaction by recovering equivalent damages. Now, that's not true here in America. Nope. You come to try and burn my house down, I have every right to shoot your ass. You better get off my property. You got 4 seconds to make movement towards leaving. We ain't waiting. I'm not going to let you destroy all my personal belongings and my house. Fourth Amendment. The right of the people to be secure in their persons, papers, houses, and effects. That's right. We have that right to be secure. But again, this is part of the English common law. And sometimes in here we'll read where, because at the time this was still, when this Blackstone was writing this, as America was already going, and we started the American common law starting clear back to 1606. And essentially the first ordinance of Virginia started more of the American common law. You see, while we brought the American common law with us over here, we only adopted certain parts of it, not all of it, which Blackstone admits right here in this book 1. And I believe I covered that last week. It was in the footnotes. So he admits that there is a difference between the English common law and the American common law. So, but then here we go. Here's a contradistinction, right? But no suitable atonement can be made for the loss of life or limb, and the indulgence shewn to a man under this, the principal, sort of duress, the fear of losing his life or limbs, agrees also with that maxim of the civil law. So that would be Roman civil law, whatever all that there says in Latin. X. I wonder if X down here breaks it down. FF.48.21.1. Okay, Rob, what is that? And I wonder if that's FS, because they used F's as S's back in the day. I wonder if that's feudal system. I bet it is, feudal system. Very possible. The law not only regards life and member and protects every man in the enjoyment of them, but also furnishes him with everything necessary for their support. For there is no man so indigent or wretched, but he may demand a supply sufficient for all the necessities of life from the more opulent part of the community, by means of the several statutes enacted for the relief of the poor, of which in their proper places. A humane provision, yet though dictated by the principles of society, discountenanced by the Roman laws. For the edicts of the Emperor Constantine, commanding the public to maintain the children of those who were unable to provide for them, in order to prevent the murder and exposure of infants, an institution founded on the same principles as our foundling hospitals, though comprised in the Theodosian Code, were rejected in Justinian's collection. So, that goes back to part of that Roman civil law, is that they created the hospitals as foundlings and for mothers to abandon their children. And technically speaking, the way it went was it went over to the church. And they'd put him in there. I can't think of the verbiage of that right now. Was orphanage. That's how orphanages came about. But in our history, what I have read is that through the church, and that's where we're supposed to be giving our taxes or tithing of 10%. And the church was supposed to be part of the congregation, congress of the community. And that's where we went when we needed help for the poor. The poor would go to the church because the rest of the community was paying their tithes to help support the poor. I think that's a beautiful way to do that. That way it's done by the people. It's of the people, by the people, and for the people. Had nothing to do with government. Kick rocks, get out of here. We got this. These rights of life and member can only be determined by the death of the person, which was formerly accounted to be either a civil or natural death. The civil death commenced if any man was banished or abjured the realm by the process of the common law or entered into religion. So like you take a vow of silence or whatever, and you go into, you make your sacred vow to go into religion, you can lose that kind of stuff. So that is, went into a monastery and became there a monk professed, right? In which cases he was absolutely dead in law, and his next heir should have his estate. So that's the key to that right there, is when you do this certain thing, you're dead in law, which means none of that stuff applies. Because for such banished man was entirely cut off from society. And such a monk, upon his profession, renounced solemnly all secular concerns. And besides, as the popish or popish clergy claimed an exemption from the duties of civil life and the commands of the temporal magistrate, the genius of the English laws would not suffer those persons to enjoy the benefits of society who secluded themselves from it and refused to submit to its regulations. A monk was therefore accounted civiliter mortimus, dead under the civil law, Roman civil law. And when he entered into religion, might, like other dying men, make his testament and executors, or if he made none, the ordinary might grant administration to his next of kin, as if he were actually dead intestate. Such executioners and administrators had the same power, and might bring the same actions for debts due to the religious, and were liable to the same actions for those due from him, as if he were naturally deceased. Nay, so far has this principle been carried, that when one was bound in a bond to an abbot and his successor, and afterwards made his executors and professed himself a monk of the same abbey, and in process of time was himself made abbot thereof, here the law gave him, in the capacity of abbot, an action of debt against his own executors to recover the money due. In short, a monk or religious was so effectively dead in law that a lease made even to a third person during the life, generally, of one who afterwards became a monk, determined by such his entry into religion, for which reason leases and other conveyances for life were usually made to have and to hold for the term of one's natural life. Okay. Kind of what I'm gathering there is if he had a leasing some land or property or whatever to somebody, and then went in and became a monk or whatever into religion and declared his status as that still accrues and still owes, but it would go to his heirs, to the executor of his intestate, his estate. But even in the time of Popery, the law of England took no cognizance of profession in any foreign country, because the fact could not be tried in our courts, and therefore, since the Reformation, this disability is held to be abolished. As if also the disability of banishment, consequent upon abjuration by statute. This natural life being, as was before observed, the immediate donation of the great Creator, cannot legally be disposed of or destroyed by any individual, neither by the person himself, nor by any other of his fellow creatures, merely upon their own authority. Uh-oh. In other words, the laws of nature has to be observed, and it cannot be disposed of or destroyed even by himself or anyone else, because it pre-exists man, and God would be the sovereign. We're supposed to be the servants of God. Yet nevertheless it may, by the divine permission, be frequently forfeited for the breach of those laws of society which are enforced by the sanction of capital punishments. Right, like murder, thou shalt not commit murder, of the nature, restrictions, expedients, and legality of which we may hereinafter more conveniently inquire in the concluding book of these commentaries. At present I shall only observe that whenever the constitution of a state vests in any man or body of men a power of destroying at pleasure, without the direction of laws, the lives or members of the subjects, such constitution is in the highest degree, what? Tyrannical. In other words, you can't delegate that power, because we don't have the power ourselves. So that would be an usurpation of power, assuming a power they don't have. And that whenever any laws direct such destruction for light and trivial causes, such laws are likewise tyrannical, though in an inferior degree, because here the subject is aware of the danger he is exposed to, and may, by prudent caution, provide against it. Oh, I don't know, would that be a remonstrance in the middle of making it, or a petition as they go to apply it? Could be challenged the constitutionality of the statute. That'd be in the judicial branch, but that's supposed to be done by the jury to judge the law. That's one of the parts of our right to trial by jury, one of the benefits of trial by jury, and the power belonging to the people is to judge both the law and the facts. That's how we provided oversight of the legislature. We, the people, do that. So when they say judicial, that's what's actually meant there. By the jury, in the judicial. We declare that unlawful and unconstitutional. But see, they stripped us of that power. We need to take that power back. That's that all political power inherent in the people. Let's see. The statute law of England does therefore very seldom, and the common law does never, inflict any punishment extending to life or limb unless upon the highest necessity. And the Constitution is an utter stranger to any arbitrary power of killing or maiming the subject without the express warrant of law. Warrant? Like the Fourth Amendment? Warrant? Or it's warranted? Nullus liber homo says the Great Charter, that would be the Great Charter, would be the Magna Carta, Great Charter of Liberty, which words, blah, 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 destruitor, according to Sir Edward Coke, include a prohibition not only of killing and maiming, so that use of force and violence, it's in the Virginia Declaration of Rights, June 12, 1776, without the use of force and violence. Yeah, we did not authorize any part of government to use force and violence against us. Nope. But also of torturing, to which our laws are strangers, and of every oppression by color of an illegal authority. Color of authority. What was I just talking about? Clothed with authority? Color of authority? Which is actually in the Hobbs Act. Acting under color of official right. Color of authority. Just because you got that disguise on doesn't grant you special powers, dude. Sorry. And you have to acknowledge the laws of nature first. Then you have to support the Constitution with the Bill of Rights and all of our rights, because that's what government was instituted for, was to secure these rights. And you're bound to support it. And that's the maxim of law. 1, ignorance of the law is no excuse, the laws of nature. It's supposed to be self-evident. 2, to know a thing and to be bound to know it are regarded in law as equivalent. When they take their oath of office there, they're bound in law. That's in law. Suits in law, Article 3, Section 2. Not suits at common law. 2 different jurisdictions. 2 different bodies of law. And as an act of the statute, Edward the Third, Section 9, or Chapter 9, that no man shall be forejudged of life and limb contrary to the Great Charter and the law of the land. See? And again, by statute 28 under 3C, that no man shall be put to death without being brought to answer by due process of law. See? You got to follow the law of the land. Not a statute, but the law of the land. Because law of the land literally means due process of law. They're synonymous. They mean the same thing. Besides those limbs and members that may be necessary to a man, in order to defend himself or annoy his enemy, the rest of his person or body is also entitled, by the same natural right, to security from the corporal insults of menaces, assaults, beating, and wounding, though such insults amount not to destruction of life or member. So now they're getting into those breaches of peace, assaults and batteries. Preservation of a man's health from such practices as may prejudice or annoy it. Oh, what? The preservation of a man's health? We have that right naturally from the right of absolute right of personal security? Huh. Yep, we get to choose our own health issues and what we do about our health, not government. And most certainly not a private for-profit corporation. The security of his reputation or good name from the arts of detraction and slander are rights to which every man is entitled by reason and natural justice, since without these it is impossible to have the perfect enjoyment of any other advantage or right. But these three last articles, being of much less importance than those which have gone before, and those which are yet to come, it will suffice to have barely mentioned among the rights of persons, referring the more minute discussion of the several branches to those parts of our commentaries which treat of the infringement of these rights under the head of personal wrongs. Suits at common law can be criminal in nature or civil in nature, because we're talking about nature, in nature. All right. Now, this is going into section 2, or article 2. Next to personal security, the law of England regards, asserts, and preserves the personal liberty of individuals. All right. So personal security was all that I just covered. Now we're going to get into personal liberty. This personal liberty consists in the power of locomotion. Choo-choo, vroom, vroom. Okay? Of changing situation or moving one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law, which is due process of law. Again, another verbiage that they used back then, due course of law or due process of law. Plain and simple. It's not the right to travel. It's the right of personal liberty. Which again, this is one of those ones that I defeated back in 2013, 2014, that I don't need a driver's license. To the troll out there. That's one of the cases I won, one of the last 4 cases. Which is probably why they didn't file any of the traffic citations from May 1st or May 2nd last year. Well, actually, now it would be 2 years ago, 2022. The one that I just had a sham second trial. How do you try a man twice for the same crime when you lost the first time? And then, not only that, the trial by jury was only of 6, and they didn't have the authority to judge the law. So it's much bigger than that. Let's see, I've created my paperwork, I created the record, I've put them on notice. I've done the constitutionality challenge to it. They know what's up. They know what's coming. I can tell you that right now. Or at least they have an idea, a sliver of an idea of what I'm doing. And I think the judge finally figured that out with the last sham trial. My witnesses that were sitting there afterwards told me they were watching the judge's body language, and the judge knows something's up. So we'll see what happens. Squeaky wheel gets the grease, folks. So, concerning which we may make the same observations as upon the preceding article, that it is a right strictly natural. We're talking about the right of personal liberty. That the laws of England have never abridged it without sufficient cause, and that in this kingdom it cannot ever be abridged at the mere discretion of the magistrate, without the explicit permission of the laws. But see, then you got Murdoch versus Pennsylvania. You cannot convert a right into a privilege, license it, and attach a fee to it. It's a fundamental principle. Our rights are off limits. There's no subject matter jurisdiction over any of our rights. None of them. Now, we can create stuff to deal with a trespass of those rights. Sure, but you can't regulate them. You can't limit them. We don't, as a man, we don't have that authority. So how am I going to delegate a power that we do not possess ourselves first to a representative body, elected officials, public servants? How are the public servants going to make legislation on something that we don't even have the power to do ourselves first? Oh, that'd be completely illogical now, wouldn't it? That's part of that Law of Nations, Book 1, Chapter 3, Section 30. When they usurp their powers, it becomes a capital offense, also known as treason. Section 34 asks and answers the question of whether these legislators have the authority to alter the fundamental law or the Constitution, and the answer is no. How can that which is created alter the laws of its own creation? It's just completely illogical. You can't. And that's exactly what they would be doing. Because government was instituted to secure these rights, how is it that what is created can alter the laws of its own creation? Just, the original intent. Here again, the language of the Great Charter is that no free man shall be taken or imprisoned, but by the lawful judgment of his equals or by the law of the land. Where do you see statute? Nope. It's either by a judgment of a jury or by the law of the land. That's right, folks. And you know what's funny? Because I kind of essentially cited this at the end of my trial where I tried to, I basically made the motion to dismiss or judgment of acquittal, whichever he wanted to grant there. And I said, I rattled off the top of my head chapter 39 and chapter 40. And I said, if this was a prohibition on the king in 1215, it most certainly is a prohibition against government today. Let me tell you, he started moving around in his chair, getting nervous. Because that's a fact. As Blackstone is citing right here. Clear back here again the language of the Great Charter. 1215. It's almost like I know what I'm talking about. Like I've read this stuff before. Sorry, folks. Reading means reading, folks. And many subsequent old statutes expressly direct that no man shall be taken or imprisoned by suggestion or petition to the king or his council unless it be by legal indictment. Like a grand jury indictment, that's right. Or the process of the common law. Uh-oh. Oh. That is such a good spot right there. I need to mark this. 134. Page 167. I don't know. Oh, maybe that's it right here. Indictment or process of common law. I guess I've already got it bookmarked. Yeah, I thought that was an important part there. That'll be going in some of my paperwork. Yep, right there. I'll be citing Blackstone's Commentaries on the Law of England. Right there. Now, what's the remedy here when they do? Uh-oh. By the petition of right, there's that darn word or right of petition, it is enacted that no free man shall be imprisoned or detained without cause shown, that probable cause, to which he may answer according to law, not by law, that's to law, the common law. By 16, if any person be restrained of his liberty by order or decree of any illegal court, or by command of the king's magistracy in person, or by warrant of the council board, or of any of the privy council, he shall, upon demand of his council, have a writ of habeas corpus to bring his body before the court of King's Bench or Common Pleas, who shall determine whether the cause of his commitment be just, and thereupon do as to justice shall appertain. Which is where justice is to be without sale, denial, or delay. Which is, what, chapter 40 there? To no man will we sell, to no man will we deny or delay right or justice. Yeah, 12:15, that's the one I cited right there. Okay. It's not my opinion. These are facts of law. We're all reading this at the same time here, right? We all comprehend what that means and what the habeas corpus is for. The methods of obtaining this writ are so plainly pointed out and enforced that so long as this statute remains unimpeached, no subject of England can be long detained in prison, except in those cases in which the law requires and justifies such detainer. So if you're a threat to society, you've committed murder, yeah, that's a pretty good cause to keep somebody locked up in jail so they don't get out and kill somebody else, murder somebody else, or rape, or kidnapping. Those are capital offenses that warrant keeping that man or woman locked up so they don't do it again. Okay? There are certain crimes that are committed out there that warrant keep protecting the security and safety of the people in the community. And at least this act should be evaded by demanding unreasonable bail or sureties for the prisoner's appearance. It is declared by blah, 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 that excessive bail ought not to be required. So, it's not like the stuff that's written in the Bill of Rights is new. This stuff's pretty old stuff. So if it was the law back then, it most certainly is the law today. It's called succession of law. And through succession of law, rights can never be diminished. And the maxim of law is rights never die. And I actually found another maxim of law a couple months ago now, that it said that where there's a conflict between, or a conflict or a question between basically the newer verbiage of the right and the older verbiage of the right, we are to revert to the older version of the right. Why? Because it's a lot more fluffy. Has a lot more words to it, because that's the way they did it back then. And through succession of law, sometimes those words are taken out because everybody already knows. Like the right to trial by jury. Well, it doesn't say that in the Bill of Rights, that it's of 12 men of our vicinage without whose unanimous consent cannot be found guilty. Well, that's why we have to go back to the older stuff, because we've all been lied to. We've all been dumbed down on purpose. So, well, Karen, I would recommend you citing Blackstone's Commentaries on the Law of England for your next writ of habeas corpus. Citing exactly what's right here. Cite the Magna Carta. Aha. So, yeah, I had a meeting with Rod Class yesterday, and we're going to be picking each other's brains and tossing thoughts and ideas out there and our knowledge, share knowledge amongst each other and see what we can't come up with and work together. But one of the things I guess he was impressed with was I made the point that where in the Constitution did it authorize Congress to create any of these executive, so-called executive agencies, like the FBI, the CIA, EPA, BLM, which is Bureau of Land Management. Where? Where's that delegated power at? It's not there. I can't find it in the Constitution. I've read the Constitution many a times. I still have yet to find where it says Congress has the authority to create these three-letter agencies. So, like what I said, heck, we want to cut the budget. That's a pretty easy, quick, simple fix. We just abolish all of it. The whole entire executive branch. Except for what the Constitution specifically creates and provides for. How about that? Hi, Scrimshaw. Good to see you. I mean, does anybody else think there's somewhere in there that they have the authority to create those things? How about even like the World Health Organization? How about the CDC? Now I'm going to have to do a different video on this. And probably it will not be on YouTube. Because this stuff's starting to raise its nasty head again about this fake schmew. Okay, so pay attention to that one. More than likely that one will be just on Rumble and possibly X now that I've connected to X. But I'll just undo YouTube so they don't give me a strike on that one. But this needs to be dealt with, and it needs to be nipped in the butt. And I'm going to provide all the evidence that's needed for anybody else out there that wants to help shut this crap down. Or trying to come back with this crap. But a comment over here on Telegram, Luke says commerce. Right. That power is delegated to regulate commerce at the ports. And that's to regulate foreign commerce at the ports. That's Article 1, Section 8, Clause 3. And then Federalist 45. Oh, Mark, why I got you here. I know you seem to remember these way better than I can. About Confederate Republic. If you're still with us, Mark. I thought it was like 2, 4, and 6 or something. I don't know. I'm kind of out there a little bit. I'll watch for that, Mark. Where it talks about Confederate Republic in the Federalist Papers. I found it in the Documents Illustrated of the Formation of the Union of the American States. 43 and 45. I thought there was more. 72? I don't know. I'll look at 72 again. I know 45 does. Uh-oh. Yep. Yes, Anti-Federalist. There are the Anti-Federalist papers, too. All right, let's get back to this. I'm still looking over here if you can remember. I swear there was a couple other ones. Of great importance to the public is the preservation of this personal liberty. For if once it were left in the power of any, the highest, magistrate to imprison arbitrarily whomever he or his officers thought proper, as in France it is daily practiced by the crown, there would soon be an end of all other rights and immunities. Some have thought that unjust attacks, even upon life or property, at the arbitrary will of the magistrate, are less dangerous to the commonwealth than such as are made upon the personal liberty of the subject. I mean, come on. See, I'm going to reiterate this. Some have thought that unjust attacks, even upon life or property, at the arbitrary will of the magistrate, are less dangerous to the commonwealth than such as are made upon the personal liberty of the subject. To berave a man of life or by violence to confiscate his estate, property, this is probably going to be without accusation or trial, would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole kingdom. And you know what? I'm going to go ahead and play this little... Oh, Rob, now you're over here on Telegram. Nice. Okay, Montesquieu from volume 1B9, where the writer speaks of Confederate Republic as the only safe means of extending the sphere of a republican government to any considerable degree. Thank you, Brother Rob. Man, you are so awesome. You're just good at that. I'm going to, this video this morning, having coffee, and it popped up on my little Facebook stuff there, and I'm like, I'm gonna play this. I'm gonna have to go there because yeah, this is great, folks. I mean, it just reiterates exactly what I just went through and part of what I argued, what's in my paperwork from way back. Let me see if I can figure this out. I'm going to have to pull this over here. Okay, everybody ready for this?
In of itself transform a mere inquiry into a Terry stop. You may request ID during a mere inquiry. You do not need to have that RAS to request ID. Key thing here, there's a big difference legally, constitutionally, between requesting something and demanding something. How you request that ID is critical. The citizen's perception is key. The courts look to is how would a reasonable person perceive the circumstances. It is the officer's behavior, not their intent, that is the key element in determining the level of the interaction. Your language and your actions, as I just touched on. Asking somebody, do you got any ID on you, versus telling them, give me your driver's license. Two very different things legally and constitutionally. Blocking somebody's pathway or a doorway. Creating the perception that they are not free to leave. And that's what this all turns on. The moment that a reasonable person would not feel that this is a consensual encounter, the moment you have created a set of circumstances where a reasonable person would not feel that they are free to leave, that is no longer the mere inquiry. You have now, whether you meant to do so or not, you have now transformed that encounter into the Terry stop. And what do we need for a Terry stop? RAS, right? So at that point, if you lack RAS for the Terry stop and you've created those circumstances, anything that stems from that is going to be thrown out.
So, everybody get that? A request is not a lawful order. Gee, I just argued that in court. Argued it in my paperwork. Very, 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 very beginning. Okay? Very, 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 very beginning of the case. I'm just going to go ahead and close that. So, there you have it. There's a police officer who's an instructor teaching police officers that they may make a request for your driver's license, but unless you give your consent, uh-oh. And if he creates a situation in, like he did with, you're not free to leave. You understand that, right? You're not free to leave. Okay. So what's your RAS? That's what I did to him. What's your reasonable and articulable suspicion that I've committed a crime that's an arrestable offense without a warrant? Or do you have a warrant? I don't need a warrant. I need you to articulate the crime right now. Because what he supposedly placed me under arrest for, turned his emergency lights on, and chased me down, and deprived me of my personal liberty, was because I had expired tags. At 11:30 p.m. at night. So that's something I touched on in the trial. I'm like, well, at first he says, do me a favor, turn your car off. I busted him on, why did you use the word car and not motor vehicle? And then I asked him about whether or not I had, that we, the people, have to do him a favor when he asks it. And then later he's requesting. Okay, do we, the people, have to answer your requests and do what you say in your by your request? Well, the answer's no. We are not obligated to do them favors, to do their requests. What perfect timing for this video. I think I'm gonna take that video. I'm going to send it over there to the judge and say, hey, what's going on here? This is exactly what I just argued. You're denying justice. That's right, folks. Consent. And the Fifth Amendment gives us the right to not answer any questions. Okay? But there, you heard it from another man's mouth. That's a police officer training other police officers. Oh boy. Oh, dang it. All right, so we're leaving off here at a habeas corpus for the night. We're going to leave right off here. Habeas corpus, which would be 136. I'm going to change that so I have that recorded for next week. Because this is kind of my mission here, is to get through Blackstone's Commentaries on the Law of England. All right? So I want to remind people that, Thursday nights there on the National Assembly call. I guess I better pull one over here. national-assembly.net. Right here. Conference call info. There it is. Bam. Free conference call is the application that is used. Okay, and if you need help installing that on your phone, here's the YouTube channel, or your desktop, laptop. That's this one here. This one's for the smartphones. This one's for your desktop computer. And then once you get that installed on there, and again, I highly recommend installing the app. It makes it a lot easier. And then right here's the link to join. Once you do this once, it saves it in your app. So all you got to do is click on that. The next time you bring it up. But this is every Thursday night. Every Thursday night. 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. Okay? The first part of the session is assembly business. The second session is a general discussion, Q&A, and teaching. Doing education over there. I think Bill over there and Jim on Utah, he talks out there pretty good. Oscar and, of course, Jason, which I haven't really seen much of Jason lately from his hardline. So there's some podcasts for you to watch right there. He goes over the training manual, 2000-25. That's the military citizenship manual. Okay. Here's your podcast on assembly. Okay, you want to learn a little bit about that. There's all sorts of stuff on this website. Under the resource tabs, there's some videos here, assembly supporting videos. You want to learn about this stuff, get over here, get on this, and start going through this stuff. Okay? And, I don't know, what's this state national fraud? I wonder if he put me on here. Oh, there it is. I already went over this. I've already laid this out. Right here, etymology. Right there. As a noun, citizen of a particular nation is from 1887. And then, here's the law. It's from United States Code. The term national means a person owing permanent allegiance to a state. The term national of the United States means a citizen of the United States, or person who, though not a citizen of the United States, owes permanent allegiance to the United States. That's the corporation. United States Code, Roman civil law under the corporation. These are corporate bylaws. So, this is why you don't want to be a national. See? National as a noun did not come into being until 1887, after the Reconstruction Acts of 1871. Changing our form of government into a corporation is only found in the bylaws of the corporation. And here's that, Book 1, Chapter 19, subsection 212 from Vattel, Law of Nations. The citizens are the members of the civil society, bound to perform what? Bound to this society by certain duties and subject to its authority. You can't make this stuff up. Well, I mean, I guess you can. Clearly they do. But I don't. I read and I cite the law as it is written. And this is where it is in Article 6, Clause 3. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial offices both of the United States and of the several states shall be bound by oath or affirmation to support this Constitution. They're the citizens. The public servants are the citizens. The inhabitants, as distinguished from citizens, are foreigners who are permitted to settle and stay in the country. Bound to the society by their residence, they are subject to the laws of the state while they reside in it, and they are obliged to defend it because it grants them protection, though they do not participate in all the rights of citizens. They enjoy only the advantages which the law or custom gives them. The law we're talking about here is the law of nature, the common law, not statutes, not even the Constitution. The perpetual inhabitants are those who have received the right of perpetual residence. These are a kind of citizens of an inferior order and are united to the society without participating in all its advantages. That would be what? The people. As it is written from the law of nations. As it is written. Not my opinion. These are facts of law. Now, somebody out there, you claim you're an American state national or whatever, all the way to the tippy top there. Can you cite the law? Show me the law about national. Because this is the best you're going to find is United States Code. So, I just debunked national. Again. And who in the heck are the citizens? They are the public servants. So this destroys sovereign citizens. And see, this is Artist Confederation. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of the free citizens in the several states. Can't get any more clear than that. What did I write here? Our founders created a one-of-a-kind form of government, a capitalist confederate republic. Capitalism refers to an economic system in which society's means of production are held by private individuals, organizations, corporations, business, not the government, and where products, prices, and the distribution of goods are determined mainly by competition in a free market. That's what capitalism is really about. And then you add the right to contract your labor as you see fit. Our right to contract is unlimited. That's under capitalism. Yep. Just saying. National-assembly.net. These are the men and women out there that have been doing this for quite some time. They know what they're doing. Okay? Yeah, unfortunately, I'm I do private classes on Wednesday night. I do Wednesday night workshop. Which, speaking of which, we can go to that right now. My website, kirkslawcorner.com. Now I'm going to have to add Twitter in here, or X. Up here is an icon for a link to social media. But here's Facebook page. There's Telegram. There's YouTube. There's Rumble. And this is the Patreon for those that want to get in on the Wednesday night workshop stuff. And like I said, Wednesday, January 17th, I'm going to basically start from the beginning of this particular case that I just went through, that I'm going through. I'm going to go over the documents and I'm going to explain stuff. Okay? One little bit at a time. So some of these classes will be fairly short. Some of them will be a little bit longer. But I think it's time to go through this step by step and share that out there with people. So if you're wanting to learn, wherever that troll went out there, why don't you join my Patreon and get in there and learn this stuff. Instead of coming onto my channel and asking snarky questions. Because clearly you don't know. I do. And I can prove it. So, yeah, other than that, if you'd like to help support, you can join Patreon, which is Tier 1. Tier 2 is basically, one's $5 a month, the other's $10 a month. It's a cup of coffee a month to help support me in my endeavors, which would support this right here, Monday Night Law. I do this for free every week, besides for holidays or having to take a day off, take a night off. Other than that, Tier 3 is what gets you into Wednesday night workshop. Now, for those that want a little bit more time with me, one-on-one private education, dealing with a particular issue or whatever you have, that's Tier 4. Okay? Other than that, anybody would like to, because I don't have any other way of doing digital donations, you could send it over to the office, and that's the address right here, 6477 West Fairview Avenue, Suite. It's actually Suite G, as in golf, no longer Charlie. Moved upstairs. G for God. Want to thank those that recently sent me a donation over there. Mark and Mary, appreciate you. And again, just wanted to let people know that I got the new space there, and it's set up as a classroom. I don't know, is there a way I can pull that sucker up? Probably not right now. Anyways, another time, unless you're on Telegram, you already know. Okay? So that concludes tonight's Monday Night Law. Thank you all for being here. Thanks for the likes, follows, and shares. And I recommend following me on my social medias. Mostly Telegram is where I do a lot of my postings and stuff anymore, because I don't get censored there. Telegram doesn't censor me there. So, not yet anyways. Although, they have seemingly removed the one video there that I've put it on there 3 times now. The original video of me addressing the Idaho legislature. Somebody took a hold of that and made a TikTok video out of it. And that thing's like all over the frickin' place out there. So, thank you, Brother Art. Art over here on YouTube says, we need to have trolls come in here more often. You're on fire tonight. Yeah, well, you know. All right. God bless you all. Have a wonderful week, and we'll catch you next Monday. And again, if you want to get in on Wednesday Night Workshop, get signed up.